All right, everyone, this is Jonathan Wyatt, this year's chair of the affiliate committee. Thank you so much for coming back for another episode here. Before we get into the program, we are about to do the Pledge of Allegiance, so be sure to put your hand over your heart for pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right. Again, good morning, everyone. Today we have Anita Steberg with Steberg Law Firm with Prop 19 updates, what we know so far. Anita, go ahead and take it away.
Well, thank you. So when we started talking about bringing this presentation to you, I wanted somebody who was on the front lines of this type of law. Prop 19 will change the landscape for real estate, as particularly transfers and reassessments, as long as some other things. And so I wanted somebody to present this that was on the front lines. And so I reached out to Jennifer Shari, and because I know that particularly her, but her and her firm have been dealing front lines on this issue as legal issues have came up. Jennifer Shari is a partner at Timmerman Siley Coleman LLP in San Jose. Her practice includes estate planning and estate administration. She has a particular panache and expertise for property tax issues, and she has enjoyed following Prop 19 saga since California enacted it in November 2020. When Jennifer isn't bogged down by COVID restrictions, she enjoys cooking, hiking, and playing poker. I'm going to turn the time over to Jennifer for the presentation so that we can learn all about Prop 19. Thank you, Jennifer.
Awesome. Thank you so much, Anita, and so great to be here with all of you. Let me just share my screen here. All right, so Proposition 19, what we know so far. So we're going to see some changes in property tax, some changes in inheritance, and some changes in retirement. All right, so first I want to start out with what is property tax? So property tax is levied by the county assessor's office and is paid to the state, right? It is a state and local tax. It is not a state tax. I know that a lot of people get confused by the sheer number of taxes that we pay in California. But I like to remind people to stay in your lane when you're thinking about taxes. So if you're thinking about a property tax issue, you only want to be thinking about the property tax issue. If you're thinking about an estate tax issue, you only want to be talking about an estate tax issue. And same with income tax. The difficulty is that a lot of these different types of taxes use the same terms. So a client might come to me and say, well, if I sell my house, then my taxes will go up. Or if I transfer my house to my child, then my taxes will go up. And my question is always, well, what taxes are we talking about? Because one transaction can oftentimes have a lot of different tax impacts at different levels. So today we're going to stay super focused on property tax. Right? So property tax is based on the value of property, sort of. And so we all know about Prop 13 that came into effect decades ago and essentially said that when you own a property, we're not going to let your property tax increase too quickly, right? So this is how you calculate it. So your purchase price of the property is your basis, plus any improvements. Let's say you add on to a house or you put property on land, a house or something like that. That's going to increase your property tax basis, right? The assessor has a right to come out, appraise those new improvements to the extent they are above and beyond what was previously on the property and assess a property tax, right? So that purchase price plus improvements is your property tax base. Then Prop 13 says that your property tax base, right, the value, can increase no more than 2% a year. Now, it doesn't always increase 2% a year. Sometimes if there's a year where values are going down or, the market's not doing well, it won't go up that 2% a year, but that's the absolute max that it can go up. And then your total tax is 1% of that basis. So I know a lot of people get those 1% and 2% figures confused, but 2% is the amount it can increase and 1% is the total tax. So let's look at this. So you purchase a house for 100,000. Let's say you were in Santa Clara County in the 70s, and it was a really nice house, and you purchased it for 100,000. So over 20 years, that 2% increase results in a basis of 145,000. Well, I can only imagine what that house is really worth, right? It's really worth, I'm sure, much more than that 145,000 over those 20 years. And so what you end up with is this sort of lopsided property tax benefit, right? People that purchase their homes and hold them are paying less property taxes than when houses are turning over. So generally what the assessor is looking for is a reassessment, right? And that means we're going to restart the property taxes. We're going to remove that low base you have, that 100,000 or that 145,000, and we're going to go up to fair market value. So here's a reassessment. Reassessment is based on change in ownership. So a change in ownership can occur from a sale, a gift, or a death. Right? Change in ownership doesn't mean you paid money for it. It just means the person that owned it before is different than the person that owned it after, right? That's your threshold matter. Have you changed ownership? So here we have our purchase for $100,000, right? And over 20 years, 2% increases to that 145,000. I estimate the property taxes would be around $1,750 a year. The reason I estimate that is because 1.2%, even though the property tax itself is only 1%, there are lots of measures, mosquito abatement, various propositions that that cities and counties vote on that actually increase that and add additional fees. So when I'm estimating this for clients, I generally estimate it at around 1.2%. So if you sell that property or it's inherited, and let's say it's worth $1 million, FMV, which is fair market value, your property taxes are going up to $12,000 a year. So you can see the difference here, right? Of someone that's held that property is paying far less taxes than this new owner who is coming in on the exact same property. And part of the reason we're talking about this today is there used to be some benefits to being in a certain relationship with someone, whether that's a spouse or a parent-child relationship, to preserving that low property tax. Right. I do want to touch on documentary transfer tax. So documentary transfer tax is that item line you see on the deed that indicates that there is a fee owed for the sale or transfer of property. Now, documentary transfer tax, it does make a difference whether it is a sale or not. In other words, whether money is being exchanged. Where you're dealing with a gift, there is no documentary transfer tax at the county level. Right? The county level will not levy any tax. However, there are cities, San Jose being one of them, Mountain View being another, where there is a city documentary transfer tax and the rules are a little bit different. So if you are gifting a property with a encumbrance, right, with a loan on it, then there could be some documentary transfer tax due. So this is a different tax, but is something, clients are very familiar with property tax and they're not always aware of documentary transfer tax, but this is what this is. All right, so exclusions, right? Exclusions mean, although you've reached that threshold step of saying, yes, there is a change in ownership, we're going to ignore that change in ownership, right? These are the exclusions. An exclusion says, even though there has been that change, person who owned it before is different than person who owned it after. We're going to ignore that and we're going to allow you to keep that same low Prop 13 property tax basis. All right, so first is your spousal exclusion. Spouses can exchange property between them without any reassessment. This includes separate and community property, includes the death of a spouse, people who are registered domestic partners and then later were granted relief can also go back and get their property tax basis fixed. So spousal exclusions are incredibly broad. And the good news is spousal exclusions were not impacted by Prop 19 at all. In other words, the rules remain the same. All right, Prop 19 goals, right? So this is a revenue bill, right? This bill was to drive revenue to the state through property taxes. The reason being that there were a lot of individuals with very low property tax basis. They were not selling those properties, right? Because they were able to continue to afford to live in those homes because of their low property tax basis. And so this is a drive for revenue. Well, what's that revenue for? The revenue is for wildfire relief, right? How do we make sure that we have enough money for this wildfire relief where we're dealing with this revenue? And I see I've got a question here. Yes, thank you, Sandra. We'll get to that soon. Oh. All right, I'm not sure why I'm not able to go back here. There we go. All right, so this is going to go to wildfire relief. So the question is, how do we get that revenue? There are a lot of instructions in here regarding calculation, allocation, and tracking of increased revenue. I'm not sure how they're going to match the increased revenue from reassessments to that wildfire relief. So I do think we can expect to see more guidance on additional forms that are necessary and disclosures that maybe need to be made perhaps during that sales process as to where this revenue is coming from. So I think that individuals handling refinancing, individuals handling sales, as well as title transfer may have to deal with those sort of disclosures in the future. All right, so these are the alleged goals of Prop 19. So first goal is to remove unfair location restrictions on those who are severely disabled, victims of wildfires and natural disasters, or seniors over 55, right? We want those individuals to be able to move their primary residence more easily because under current law, it's rather restrictive. But what that means is we're allowing people to, even when they move, keep their property tax basis. Well, that's not going to drive revenue, right? That's probably going to drive revenue down perhaps for the state, depending on where they're moving, and could impact certain counties disproportionately. If there's a particular county where a lot of people are retiring to, then you end up in a situation where that county's property tax basis overall goes down if a lot of people are bringing in their low tax basis. So what did Prop 19 do to raise revenue, right? This is the revenue side of Prop 19, right? Is to limit property tax increases on family homes used as a primary residence, but eliminating those loopholes of the parent-child transfer for a variety of people that are considered to be using this to their benefit, to the detriment of the overall state of California, right? So this is what Prop 19 is doing. It has those two sides. It has one side that has either no tax impact or actually decreases taxes with respect to the transfers over age 55. And then it has the side that increases taxes by limiting what before was a very broad parent-child and very broad grandparent-grandchild transfer. All right, so some issues with Prop 19. Right? Some of these issues are it has incredibly inconsistent language with the rest of the property tax rules. It uses taxable value for a different purpose than the rest of the property tax rules use taxable value. And that's what created a lot of angst among clients, among attorneys, and even assessors. Right? Assessors wrote a letter to the BOE and essentially said, here's all the things we don't understand how to implement based on the language. So there were a lot of gaps in the law. And despite that, we only had about 3.5 months to implement all of this. So, my experience was that we were getting client calls 10, 20 times a day from people needing help with Prop 19 who could not find an attorney, right? There were just attorneys who were either unwilling to deal with Prop 19 issues because it was so confusing and so new, and the attorneys who were taking on Prop 19 issues just didn't have any bandwidth, right? And a lot of it was simple education, right? Clients needed to understand how Prop 19 would or would not impact them, and then had to sort of make a fire decision on whether or not to do something about it. So this was incredibly difficult. And I'll discuss potential delays on the implementation for Prop 19 in just a little bit. All right. So change in ownership. So first thing we need to think about is always change in ownership, right? Because that's what triggers our reassessment. So how is that defined? Proposition 19 did not modify the definition of the date of transfer, right? So where there was a death pre-February 15th, 2021, The date of death is the date of transfer. So even if you haven't actually transferred it to the child, or you haven't decided who's getting the property, you will be under the old parent-child transfer rules. If the transfer occurs after February 16th or after, or the date of death is after that, then the new Prop 19 rules will impact you. There are some counties that are saying as long as the deed was signed and notarized pre-implementation, then they will accept even if it is recorded after implementation. So there were a lot of last minute people that were trying to get their deeds in, but due to the backlog for the recording, not only because of COVID, but also because of Prop 19, they were unable to actually get that recorded stamp in time. Santa Clara County specifically has said that they will accept this. We expect the BOE to come out with guidance about making this uniform among all of the counties. One thing that we have been able to handle is if you are in a situation where there's a trust and there's been a death, and for some reason the trust doesn't work quite right with either with Prop 19 or with the old rules, you can go in and get a reformation of that trust. So keep that in mind, that even if you've missed deadlines, you had someone pass away, there perhaps is a way to correct this. The assessor's office has not challenged this in what's called a published case, right, where the court publishes a case so that it becomes law. But this has been happening repeatedly without challenge from the assessor's office. So there are sometimes, even though it seems all is lost, there are sometimes legal options to sort of correct something that may have gone wrong. All right, ownership is important. So I always tell people this, especially with Prop 19, you had a lot of clients who wanted to say, well, shouldn't I just add my daughter or my son to title? Who really owns it? Can I still live there? And so that brought to a head a lot of these issues. So one thing that is important for property tax purposes is whoever is on title is presumed to own the property. So if you have someone on title that doesn't really own it, such as someone who was put on for financing purposes, whether that's a parent, a child, or a friend, that needs to be corrected as soon as possible. As these rules surrounding reassessment change, it's really important to have title be correct, because if you allow title to be incorrect for years and years and then say, oh, well, they really didn't own it, so we shouldn't be reassessed, I think that's going to be a hard argument with the assessor, especially in the way that they are sort of pursuing this revenue under these new rules. Where you have entities or trusts, right? An entity being an LLC, a corporation, a family limited partnership, anything like that. They are what's called see-through entities. So essentially the assessor's office ignores the fact that title is in the name of the entity or in the trust and goes and says, who has the real beneficial ownership of this, right? Who is the member of the LLC, the shareholder in the corporation, or who is the beneficiary of the trust? So keep that in mind, that simply keeping the asset in trust or in an entity, even though people are passing away or making transfers, isn't going to be satisfactory to avoid reassessment. So because it is about who has that beneficial ownership. All right, so I'm going to touch on the old rules. So under the old rules for the parent-child exclusion, right, this is for transfers that are or 2/15/21 and earlier. Anything between a parent and a child, right, a transfer of a property between a parent and a child would be permitted and excluded from reassessment if it was a primary residence and that primary residence exclusion was unlimited. That means if you had a property in Malibu worth $40 million, but your property tax basis was only $1 million, you could transfer that to your child and they would continue to pay property taxes at that $1 million level. Now, remember, I'm not saying it's income tax free or estate tax free or gift tax free. We're staying in our property tax lane, right? But you could transfer that primary residence. It didn't matter how much value the primary residence had. As long as you were living there, you could transfer it to your child. And the child did not even have to use it as their primary residence. They could rent it out, they could sell it, they could do whatever they wanted. Then you had another $1 million of assessed value for other property, right? That $1 million could be industrial property, it could be rental property, and it's based on the assessed value. So again, if you have a property that's worth 5 million, but has an assessed value of 500,000, you're only using 500,000 of that $1 million assessed value, right? So you still have another 500,000 left, and it is per spouse, right? It's 1 million per spouse if you have a married couple. In addition to that, spouse of a child are included, and children of a spouse, right? So if you have a blended family where there are children from prior marriages, you can use these exclusions for those individuals. And in addition, you can use these exclusions for your daughter-in-law or son-in-law, right? If your child is married. So this was an incredibly broad exclusion that allowed a lot of property to be transferred without reassessment, right? Through inheritance. New rules, right? The new rules are far more restrictive for Prop 19. So first, the transferor must be taking a homeowner's exemption or a disabled veterans exemption, and it must be their primary residence, right? So that's step one. You have to make sure the person transferring the property is using it as their primary residence. Second, the person who receives the property, right, the child in most cases, must take the homeowner's exemption within 1 year or the property is reassessed, right? So you only get this parent-child exclusion if it's a primary residence on both sides of the transaction, which is a brand new rule. In addition, the exclusion from reassessment is no longer unlimited on this primary residence and is limited to $1 million of assessed value. And I'll give you some examples of how that math works in just a second. So what did we lose? We lost the unlimited primary residence exclusion, right? You can no longer transfer that $40 million Malibu property and have your child paying at $1 million of assessed value. You lost a transfer of any non-primary residence property without reassessment. You also lost use if you had a bypass trust where a spouse had passed away first and had a bypass trust. There were some special rules that allowed you to double up on that $1 million exemption, right? That's also gone because there's just no transfers of non-primary residences. I know I have some questions. I will address them after I get through this and see if some of that answers your questions. So requirements for primary residence. So it's called a primary residence, a principal residence, and a family home, depending on where you look, right, in the Constitution and statutory scheme. So that's part of what made Prop 19 confusing is this bill or proposition referring to the same thing that the prior law was referring to? Got to take that homeowner's exemption. Land is included only to the extent necessary for the primary residence, right? So a lot of people were saying, oh, well, I'm going to go make this other property my primary residence that has a whole bunch of land. Unless you're in a family farm situation, you're not going to be able to do that. The only part that's going to be excluded is that for the primary residence. For those of you that were going to get creative and say, well, you know, we got two spouses, let's have them each have a primary residence. Can't do it. There's a BOE rule that indicates that spouses cannot have separate primary residences. If you are married, you've got to have, it's got to be one primary residence. You can only take that one homeowner's exemption. And a bypass trust can hold a primary residence. So even if you have a bypass trust where there's a pre-deceased spouse, this does not stop you from using the new Proposition 19 rules. All right. So here's that new primary residence exclusion. It's a completely new formula for a calculation. It used to be that we had the unlimited exclusion on the primary residence and then 1 million of assessed value on the non-primary residence. This is just a completely new way of dealing with it, right? So here's some examples. So you have to sort of do essentially some algebra here. So if fair market value less assessed value is less than or equal to 1 million, then the reassessment is avoided, right? So basically, if your fair market value and the value that you're paying property taxes at, if the difference between those two is less than $1 million, then you don't need to worry about that. You can just transfer the property and the child will pay the same property taxes that the parent is paying. If the difference between assessed value, right, what you are paying property taxes on, in my earlier example, that $100,000, and the fair market value are more than $1 million apart, that's when you've got to start to do some math, right? So here in my example, we have an assessed value of 500,000, right? So they're paying taxes on 500,000. So about 5,000 in property taxes a year. Their fair market value is $2 million. They'd be paying about 20,000 a year, right? So we can see that there's a $15,000 delta in what Prop 13 is protecting for them. So we do the math, we note that the difference between fair market value and assessed value is more than $1 million. So we know we're going to get some sort of reassessment here. So then what we do is find out what that reassessment will be. And we can see that our new assessed value will be $1 million. So instead of paying $5,000 a year in property taxes, the child is then going to pay $10,000 a year in property taxes, right? So their assessed value increased to meet that $1 million threshold. All right, so now we're going to look at some questions. How does Prop 19 affect property taxes when a parent adds their child to title when both reside in the home as their principal residence and the child does not have the home as their principal residence? So if they are both on title, they may be under the joint tenancy rules. If they are under the joint tenancy rules, then there will be no reassessment at the first death. If a child is added to title that does not live in the home, which gives a child 50% ownership, is only 50% of the home reassessed at market value. So it depends on how you add the child. So if you add the child as a joint tenant, then there will be no reassessment because you become ordinary joint tenants. You do, I think, run into some gift tax issues and perhaps some rental issues depending on how that's structured. But if you add them as a joint tenant, there won't be any reassessment. If you add them as a tenant in common, then there would be a reassessment of 50% to the extent that the child does not live in the home. All right. Does a disabled child qualify that lives with parents? I'm not sure how to answer that question. Qualify for what, since they live in the home? But feel free to re-ask. If the county doesn't make the 2% assessment in year one, can they add it down the line in better times? Yes, they can go back and do a true up of those. Confused on the 1% versus 2%. So 1% is the tax levied. 2% is the increase from the assessed value in year one to the assessed value in year two. Can we get copies of the slides? Of course. Isn't the homeowner's exemption automatic when, oh no, sorry, I've gone to my slides. All right. Isn't the homeowner's exemption automatic when purchasing? If you fill out the box on the preliminary change in ownership report that indicates that it will be your primary residence, then they should automatically add the homeowner's exemption. I will say that a lot of my clients receive each year confirmations that it continues to be their primary residence, where they have to fill in their social security number to ensure they get it. It's worth checking, because if you don't have the homeowner's exemption, you fall outside of this rule. So even if that's an error by the county, that would be an issue for future transfers. Property tax transfer. Parents aren't 55 years old, but have a severely disabled daughter and had to move as a result. Do they qualify? Daughter would need to be on title, because that's again, ownership is important, right? We're seeing through who is on title, and that's how the property tax exemption is going to work. All right. Back to our Q&A. Is it an advantage to have your spouse added to title or leave him off? For property tax purposes, it frankly doesn't make any difference. For community property, separate property, estate tax planning purposes, that is a question that I could go on and on about. So I'm happy to answer that if you have a more specific property tax question, but there's a lot there. Is Prop 19 for CA only? Yes, it is. It's only a California rule, and we're only talking about California property tax. Each state has their own way of dealing with property tax. How about ownership with right of survivorship? Is that handled the same as the joint tenancy rules? Yes, so a right of survivorship is a joint tenancy. And if you have community property with right of survivorship, you fall under the spousal exclusion anyway. Does the reassessment work the same way if the property is in joint tenancy with sister and brother? Yes, it does. And that's because joint tenancy rules are separate and apart from the parent-child transfer. The joint tenancy rules is just, it's just a different rule. And I'll discuss that in a few slides here. In the example you have on the screen, if the FMV was 1.5 million and the original assessed value was 500,000, what would the tax implications be? So in that case, because you're only 1 million apart, there's no reassessment whatsoever, right? Because you're only 1 million apart. So that's the first part of the equation where we go, if FMV minus AV is less than or equal to 1 million, then reassessment is avoided. So no impact. Some people, when refinancing, deed a spouse off and then back on after the refi. So again, spousal transfers were not impacted by Prop 19 at all. And so any transfer to a spouse, no matter what you're doing, refi, taking them on or off title, transferring community to separate, doesn't matter. They're going to go ahead and be excluded for property tax purposes. I added my daughter on title as the joint owner on a property I purchased in 1973 at 35,000 and is worth 1.3. Does she pay the same taxes after I pass on? Yes, because you're falling under that joint. Well, so you say joint owner. I guess I don't know if you mean joint owner as a tenant in common or whether it is a joint tenancy. If it is a joint tenancy, you fall under the joint tenancy rules. If it is a tenant in common, unless you are living in that property and then your daughter lives in that property, no, you will not enjoy that same low property tax basis. Why does 500K get added to FMV and then subtracted? That's confusing. I agree. I didn't write the law. I just created an algebraic equation based on what the law says. As for daughter who is disabled, she is a minor. So can she go on title? Not unless you're creating a guardianship of the estate, which you wouldn't do because her parents are managing those assets. So yeah, that's an unfortunate situation, and the property tax rules just don't accomplish what you need them to accomplish there. Does the basis get stepped up when a spouse dies? So this is a great example of when we're talking about property taxes, which is totally different from income taxes. So the income tax basis gets stepped up when a spouse dies, provided it's community property and that there's no other owners on title. But that's not a property tax issue and has absolutely no impact on property taxes. All right, so got through some questions there. So I'm going to move on back to our slides. So parent-child transfer pitfalls. So this is a super common problem. And it existed more when we could transfer income property and industrial property, but it still exists even with these primary residence rules, right? So mom's trust, value of 2 million, she has 2 children, and trust provides that 1/2 goes to each child, right? Child 1 shares 1 million, child 2 shares 1 million, but the house is worth 1.5 million and child wants the house, right? So how do we get the house to child 1 and the money to child 2? Because if child 1 pays child 2, the assessor says that's a sibling to sibling transfer, not a parent to child transfer. We're kicking it out, right? So here's what we do, right? Trust gets a loan. A lot of these are called Prop 58 loans or trust loans or parent-child transfer loans. But what we do is we get child 1 that home encumbered by a loan. So now it's only worth 1 million, right? They're getting their share, and child 2 gets their 1 million in cash and they avoid reassessment. Again, remember that because we are now in new Prop 19 rules, it does still have to be a primary residence on both sides. It had to be a primary residence at mom's death, and child 1 has to be living there within 1 year and then continue to live there. All right, planning pre-Prop 19. So I bring this up because I think a lot of you are going to be seeing funky deeds, funky trusts, some entities that you don't expect to see. And then as we continue, right, people are going to want to make sales. They may not have a great understanding about exactly who owns the property because they did this crazy Prop 19 planning that maybe they understood, maybe they didn't. And maybe even some DIY deeds, right? People who were not able to get in to see an attorney still wanted to make those transfers, still wanted to be able to complete that. So this can make things really difficult with sales. So I would encourage you to pull deeds, ask clients for documents, because you don't want to do something that will cause an inadvertent reassessment where someone perhaps has done some planning to avoid that. Post Prop 19. So I think there's a lot of planning that can be done post Prop 19. People can put things in entities. They can make gifts to children of particular property. They can use those joint tenancy rules. So I think families are going to want to engage in further planning as Prop 19 continues. But there are some potential challenges, right? There are some alleged constitutional challenges. I am not a constitutional expert by any means. There are some rules under the California Constitution that say when you're making a proposition, it can only be on one subject. And this proposition perhaps violates that rule, and for that reason would be invalid. I haven't actually seen anyone file anything in court to have it be invalid, but I have heard that people think that this could be challenged. In addition, there is Senate Bill 668. What Senate Bill 668 does is say, let's delay the implementation of Prop 19 until February 2023, right? Basically gives everyone an extra 2 years. And that would mean more planning could be done, more understanding could be done. But what's really key to me is that it would give the time for the BOE to come up with rules, right? Ordinarily, when we have a property tax law, there's a whole bunch of BOE rules and annotations, right? The law may be a sentence long, and then as you dive down, you realize there are paragraphs and paragraphs of other authority that help you understand what that one sentence says. So that's really what we're looking for on Prop 19. This SB 668 was only put up February 19th, right? So just a month ago. There was an initial hearing in the Senate on March 3rd, and I'm keeping track of it on the legislative tracker, but I haven't seen any update thus far. So who knows, but it could be something we see in the next couple of months. All right, so now we're going to move to the other side of Prop 19, right? The over 55 exclusion, right? So here we have our old rules. Under the old rules, if you were over 55, you could transfer your property tax basis one time, right? And you could do it anywhere in your county. And in addition, you could go to some other counties, right? There were 9 counties that were participating. So this was kind of hard to use. And in addition, you could be impacted if one spouse used it and then you needed to downsize again later, right? The point of this was really to allow people to downsize as they got into retirement. Old rules are you must purchase the replacement dwelling within 2 years, and it has to be of equal or lesser value. In other words, you can't go and buy a more expensive property. You have to buy a property that is worth equal or less of the original property. So here's the problem, right? Mom and dad want to downsize. Mom and dad are over 55. They downsize one time. Mom dies. Dad wants to downsize again. Well, he can't because mom and dad were married and they were both on title. They both used up their over 55 transfer, right? So what are the new rules? The new rules say that individuals over 55 can make 3 of these types of transfers. In addition, all counties are now in. In other words, counties cannot decide to opt out. So now you can move anywhere you want in California, and you can buy any property you want. If you want to buy a more expensive property, you can do that. If you want to buy a less expensive property, you can do that. If you want to downsize again later or upsize, I suppose, you can do that, right? So this hugely opens up the arena for those individuals. In addition to having a limit of individuals over 55, if you are a victim of a wildfire or natural disaster, you can make unlimited transfers. You do have to have the wildfire or natural disaster must have destroyed at least 50% of the property. It's not clear whether that's 50% of value or 50% by volume of the house. So that's something the BOE will have to comment on, but it is an unlimited transfer. One outstanding question that people have is for transactions that straddle that effective date of April 1st, does it count against the 3, or is it just included in the 1 and then you get an additional 3? It's not clear at this point. I think certainly you can do that, right? You can have that 2-year time period be on both sides of that April 1st deadline, but I would assume it's going to count against those 3 exclusions. So here are our retirement community individuals celebrating because they can now move wherever they want and have some more flexibility, right? So to describe how this works, right? Old property is sold in year 1 for $1 million and has an assessed value of $100,000. New property purchased in year 2 for $2 million, right? So they're saying we want to move into this $2 million property. So the assessed value on the first $1 million of value is your original 100,000, right? You're transferring that 100,000 equally to that new $2 million house. The remaining $1 million of value is assessed at full value, right? So when you move into that $2 million house, you keep your 100,000 of assessed value from the first 1 million, and then you have to pay taxes on that second 1 million. But it allows you to move into a more expensive property, right? And you don't actually have to downsize. Example 2, old property worth 1 million with assessed value of 100,000, new property purchased in year 1 for 2 million, right? So you've purchased this property, but you haven't sold the old one yet. Upon sale of the old property, as long as it is within 2 years of the new property purchase, then you can transfer that assessed value of 100,000 and your calculation will be identical to that above. All right. Yes, joint owners, she and her family are staying with me. Okay, perfect. Where can I get this material to review and understand clearly? So again, I'm happy to provide my slides. And there are also a lot of resources on the BOE website. There are resources on the Santa Clara County assessors website. There's a lot of, FAQs and rules, and there's even an assessor's handbook. It's about 400 pages, but it actually does have a lot of good examples if you sort of are willing to troll through that. Who can have unlimited transfers? So anyone who is a victim of a wildfire or natural disaster, provided that more than 50% of the property was destroyed. So this can either be they can rebuild on that same property and keep their basis. In other words, the assessor isn't going to send out an appraiser and say, oh, well, did you build a different house or something like that, right? And anyone who just moves from that property, let's say you sell that property that was destroyed and move somewhere else. Can we get your narrative along with the slides? I guess that depends on the Association of Realtors and how they've handled this presentation. Can I buy first, then sell my primary later as long as within 2 years? Yep, that's exactly example 2. So they aren't limited to 3 times. Again, the individuals over 55 and those with a disability are limited to 3 transfers, but individuals who are victims of a wildfire or natural disaster have unlimited transfers, so they are not limited. All right. Sorry, just trying to figure out where I stopped off last time.
Jennifer, I'm just going to jump in really quick. We are recording this, so when I get the slides, we'll go ahead and send this recording out to everybody along with your slides.
Perfect, excellent, thank you. All right, what if mom was in a care home? This is a difficult question and one that the assessor has come out with and said, we really don't know what to do here. We need some guidance from the BOE. I think if mom is in a care home, but there is, she has an intent to come home, even if she's unable to, perhaps that is maintained as her primary residence, but that's sort of an unresolved issue. I have a client that sold primary in Santa Clara County and bought in Santa Cruz October 2020. Can they still transfer prior tax base? So it sounds like both sides of that transaction occurred before April 1st. So I guess I'd have to look if Santa Clara and Santa Cruz were both included under those old rules, and that's what would control. Oh, went to my, sorry about that. All right, are you able to re-explain the difference between annual assessments at 2% versus 1%? So the annual assessment, let's say we have a property worth $100,000. Next, and the taxes are at 1%. So your taxes are $1,000, right? That's the 1% figure. Is you take the assessed value, the $100,000, and you say, what is 1% of that? That's what I will pay in taxes. In year two, the assessor can say, okay, in year one, your property was worth $100,000. I can now make it worth $102,000 for purposes of taxes. You would then pay 1% of $102,000. So that's how that works. All right, perfect. So closing this here and going back to the slides. Original co-owners, right? This is what we were talking about with joint tenancy. Any interest that is a transfer with a joint tenant. So if you go mom to mom and daughter as joint tenants, when mom passes away, you don't end up with any reassessment. When daughter passes away, there will be a reassessment, right? And daughter is not going to be able to then add other joint tenants. That will be a reassessable event because you have to be an original, what's called an original joint tenant, right? So mom and daughter were those original joint tenants. So you can really only do this once. There are a variety of other issues, I think here related to income tax, estate tax, gifting, step up in basis that I think in general make just adding a child to title probably a bad idea. But certainly this is a potential easy way to handle this. Entity arrangements, I bring this up because a lot of people were doing this as they did Prop 19 planning. Essentially, and I'll go through this quickly and you're welcome to review the slides and see how this works. But essentially where there are transfers within an entity, right? Like let's say ABC LLC owns property and there are transfers with who owns that LLC. You can actually put yourself in a situation where you're not ending up with a reassessment long term, right? You can transfer from parent to child, and even though it's not a excluded transfer, as long as no one is owning too much of the LLC, then you can avoid reassessments. So this is something we did a lot pre-Prop 19 implementation in order to avoid future reassessment. There are ways to use the entity rules now. You do have to take some time to do those transfers because you have to go kind of in and out of entities, but it is something we can accomplish post Prop 19. So to kind of give you an example of how this works, right? A parent owns rental property and A has 3 children. A transferred 1/6 of the property to each B, C, and D before February 15th, or perhaps they all bought it together, right? So A owns 50% and B, C, and D own 1/6 each, which is in aggregate 50%. Well, they all transfer their interest to an LLC. Because they own the same percentage of the property and the LLC, this is an avoided transfer, right? There's no reassessment, it's excluded. Now A dies, right? Parent dies. Because parent only owned 50%, that 50% goes to B, C, and D without reassessment. And you can see the benefits here. One is ordinarily, because this is rental property, if A had died and it hadn't been in the entity, there would have been a reassessment of property tax as to 50%. And 2, B, C, and D now own 1/3 each, and they can go do their own entity planning because none of them fall above that 50% threshold. Now, this is an oversimplified example, but I think it's a good illustration of how entities can avoid reassessment. Now, I don't know how long it is before the legislature or another proposition closes this loophole, but it's kind of the planning we have right now. So we're going with it. So just some takeaways, and then I'll get back to Q&A as well. So Prop 19 is vague and complicated and risky. So I would encourage you to be super careful when giving advice to clients. You know, there are people that are interested in handling Prop 19 issues and people that are not interested in handling Prop 19 issues. I just think there's so much out there that is unknown that even answering a simple question can create some risk because there are so many different factual circumstances that can impact that answer. And in addition, there's so much in Prop 19 that we don't know yet, right? That hasn't been clarified by the legislature or by the BOE. So certainly take caution. If it's legal advice, refer it to an attorney, let it be their problem about whether to decide to answer the difficult questions, and keep up to date. Right. These rules are constantly changing. Even the assessor really doesn't know what's going on. I don't know if when you had the Larry Stone presentation, whether that was communicated. I know that when I went to his presentation, I think it was February 4th. So it was before the implementation. He kind of said, hey, here's all the things we don't know. And so just keep up on that, definitely follow SB 668 if you're interested, but just let clients know that it's a bit of a fluid situation, right? It's okay to not have all the answers, especially when the law isn't giving us those answers. So here's my contact information. Feel free to reach out. I will tell you, email is the absolute fastest way to reach me. I have it on my phone. I check it constantly, whether that's bad or that's good, who knows, but that definitely is the fastest way to get a hold of me. All right, so we will go back to questions here. But did you not say it's a bad idea to add children to title? So again, adding children to title can be good for property tax reasons and bad for a whole bunch of other reasons, right? So you can't make a decision about whether to add a child to title without looking at a huge amount of other things. You have to look at that client's estate planning goals. You have to look at the size of their estate. You have to look at what other assets they have. You have to look at what their needs are going to be as they age. So even though this presentation, I keep saying, stay in your property tax lane, staying in your property tax lane is not a good way to make decisions, right? If you're only making decisions based on property taxes, there's probably something else you're not taking into account. The entity example was pre-2/16/21. How does that apply now? So first, for those that co-own property and they're not in an LLC, it might be advantageous for them to get in an LLC. And that's something you can still do now, and the law is exactly the same. So what that illustrates is how co-owned property can avoid reassessment if you take the right steps before that person passes away. In addition, you can still do entity planning now, right? You can put everything into an LLC and a parent can then make transfers within that LLC to the child. So there's a lot of entity planning still out there and available despite Prop 19. Kim Evans, oh, shoot, there we go. Okay, here's contact information just so it's up there. All right, yes, Temerman is Bob Temerman. He's our founding partner. All right, going back to sister and brother joint tenancy, if one passes away. So again, if they're original joint tenants, right, if they took the property as joint tenants, then if one passes away, there's no reassessment. I think that's it.
And if you have, I'm going to hop in, and if you have specific questions, either for your situation or your client's situation, feel free to reach out to Jennifer Shari. Her contact information is on the slides. It's also, excuse me, Jody put it into the chat, where you can schedule a attorney-client confidential consultation and talk about different things that you are considering to get specific answers to your specific situation, or your client can get answers to their specific situation. As Jennifer said, right now we're talking only about property taxes, but there's a host of other factors to take into account that is outside of this presentation. And Jennifer and I could probably geek out for a couple hours talking about it, and everybody else would be absolutely bored. So,
absolutely.
And Jennifer, thank you so much for sharing all this great information. It's by far, your presentations they're just fabulous, and they're some of my favorites to attend and listen to. So thank you so much. And